everyone, to this month's Startups Streamlined. I'm Lindsay Carastensel, a partner in the New Ventures Practice Group, but let's be honest, we're not here to talk to me. We are here to talk to one of my partners, Steve Stransky, who's a partner in our Privacy and Cybersecurity Practice Group. He helps clients devise strategies to assess and mitigate cybersecurity and privacy risks, respond to cyber attacks and data breaches, and maintain compliance with federal, state, and foreign laws and regulations governing data protection. So today we're going to cover off several factors and business factors and business for our business entities that we need to consider when assessing data protection obligations. We're going to discuss different levels of governance and how we need to think about it, including those state and federal regulations, and maybe touch our toes into some international waters. We'll see where we go there. But we're also going to explore other aspects of business that businesses must consider when developing their own cybersecurity and security measures to safeguard their assets and counter potential security breaches. Yikes, all of that seems like very, very overwhelming and scary. So I'm hoping Steve can simplify it all and put our minds at ease. But as always, if you have questions as we're rolling through, please drop those into the chat and we will pick them up either at the tail end of the discussion or we'll jump right into them while the topic is hot. But please don't be shy, because if you have questions, chances are really good that someone else has a question out there too. So do not hesitate to bring those up. So first and foremost, Steve, thank you for joining us today.
Thank you for having me. It's great to be here.
Yeah, I'm very excited. This topic is always a little, I think, overwhelming to businesses of all sizes, whether you're a publicly traded company or you are just getting started. These are definitely things you need to think about if your business at all touches the internet, I would assume. Is that a fair statement?
Even if it doesn't touch the internet, if it touches data, then
there you
yes.
go. There you go. So I think with that, let's kind of ground everyone in some terminology before we kind of get into some meatier questions. But when we think about data security or cyber security, what does that really mean? You know, tell us what the definition of that is in your mind.
So unfortunately, depending on which law actually applies, there's going to be various definitions of what's meant by cybersecurity. Generally, when we think of cybersecurity, we think of the security measures that an organization implements from the technical side, an organizational side, a physical security side, to protect certain types of data in an organization's custody and control. And so the legal requirements generally focus on protecting personal data. And then, of course, personal data has a variety of definitions depending on which law you're talking about. At a very high level, personal data refers to any information that can be used to identify an individual. So you could think of your name, your phone number, your email address, your residential address. Right? Those are in high level what we mean by personal information. But some data protection laws are more narrow, and they only apply to sensitive personal data, like your social security number, your driver's license number, your passport number. So unfortunately, if you're an organization involved in international business or engaged in business across many states within the United States as well, you're going to be subject to a variety of data protection laws that all have their own unique definition of what data privacy is, what personal data is, and of course, what cybersecurity requirements you have to implement.
Oh my, yeah. And so the schema, it feels like it's very complicated, if you will, right? Because I feel like we have federal laws, we've got state laws, and we've got these international laws that we have to comply with. So when you're advising clients and you're thinking about, hey, you know, someone comes and says, hey, we need to either improve or we need to develop a data protection program to comply with different rules, regs, et cetera. How do you even identify a starting point? You know, where do you begin?
Yes, certainly. We can talk a little bit about what those requirements are in the United States in a minute, but the starting point of, where's the starting point for organizations and understanding what requirements they have. You have to know your data, right? That's an expression that we use a lot, is know the types of data that you collect. It's almost the W's, if you remember, the who, why, what, when, and where. What type of information are you collecting, both on your own internal employees, as well as your customers, as well as third parties that are visiting your website? There's going to be a whole lot of data that you can collect. Generally, in the HR context, it's going to be pretty sensitive on your employees, because usually in the United States, you're collecting an I-9 form, right, that has a Social Security card or a passport card or a passport on there, driver's license number, right? A lot of sensitive information. Depending on the line of business that you're in, right, if you're direct to consumer or if you're business to business, you're going to have to need to understand the type of personal information that you're collecting on your consumers, on your business contacts. And then, of course, your websites, to the extent that you are collecting information using cookies, pixels, tags, whether you're doing online behavioral advertising, right? That's a whole nother tranche of information that you may be collecting on a group of individuals, and there's going to be laws that regulate what you can and cannot do with that. So under certain data protection laws, organizations are actually required to put together what's often referred to as a record of processing or a data map. I think of it as a giant Excel spreadsheet that identifies the type of business activity you're engaging in, again, whether it's HR, administration, whether it's marketing, whether it's compliance, and the types of information you're collecting within those categories within those categories themselves, and then who your service providers are that you're sharing that data with. So for any type of organization that's using information, if you're not retaining data on premise in your own solutions, you're using third-party software providers. You could be storing information in the cloud using Amazon Web Services, Microsoft Azure, or the other thousands and thousands of cloud service providers out there that either are their own cloud or build on top of a third-party infrastructure as well. And so in order to understand, again, the legal requirements that are going to apply to an organization, you have to understand what data you're collecting, from whom you're collecting it, the purpose that you're retaining it, how long you're going to retain that data, and who you're sharing it with. And I'll just finish by noting it's when you're a startup company in particular, this is the best time that you want to be doing these records of processing and data mapping activities. Because if you're an organization that's been around for 5, 10, 15, 25 years, and you're just now trying to catch up and create a record of processing, it's very difficult to recreate, right, all the areas within your organization in which you are collecting personal information. It could be scattered across groups, agencies, departments. So starting this process in a very early stage is going to be important from not just a compliance perspective, but it's going to make your life easier as you build and as you grow. Of course, the catch-22 here is if you're a startup company, you may not have dedicated IT staff and IT professionals, and you're working day to day to make sure that you can meet your budget and pay your employees and get your products out the door. So it's definitely a catch-22, but to the extent you could provide some effort towards building a record of processing as a startup company, it'll make your life much easier as you're starting to expand, get larger, collect more data, and you can just build on top of that record of processing, that data map.
Right. So, because I know a lot of folks say, okay, well, I've got X number of resources and I really need to focus on these things and I'll catch up on that. What are the biggest risks that people face, just to kind of bring this down to reality? If you violate these state rules, federal rules, or international rules, what do the penalties look like for this?
Yeah, so it's going to range depending on the actual law that is being violated. Certain laws within the United States, particularly if you're collecting sensitive information like biometric data, some states have enacted laws that allow for a private right of action in the event that you're not properly collecting or getting consent from the end users. And that is, within the last 5 years, has really led to a significant increase of class action lawsuits for violations of very technical terms within a privacy regime. Similarly with marketing, right? At the federal level, again, we have a dichotomy between federal and state law in the United States. Our federal laws are very particular in the types of marketing that an organization can engage in, particularly engaging in telemarketing, text message marketing, SMS marketing, and the types of consent that an organization needs to obtain in order to be authorized to engage in those activities. Again, to the extent that you're in violation of those laws, not getting proper consent, not having it properly memorialized, it has led to a boom of class action lawsuits against the organizations that are engaging in these type of activities. So there is purely or solely a legal remedy that is available to plaintiffs who have been harmed by organizations that engage in marketing or privacy activities that violate these type of state laws. And what we've seen as well on the regulatory enforcement is that state attorney generals, as well at the federal level, the FTC, some regulated agencies like healthcare with the Secretary of HHS, again, within the last 5 to 10 years, they've become more onerous in the obligations that they're placing on businesses within the United States and engaging in much more frequent regulatory investigations for non-compliant businesses. So there certainly is a tangible loss that a business can incur for violating these privacy laws.
So really quickly before we bounce into the next thing, what about the international side of that? Because I know that a few years ago, GDPR came out and, we had additional rules and obligations where basically, you're internationally in some areas, your data is yours. And if it's not expunged in an appropriate way, companies can be fined. So for some of our bigger client listeners out there, what do those penalties look like dollar-wise that you've seen?
Yeah, they're significant in the multi-million dollars, depending on who the organization is. It's not unusual for Facebook to be fined $50 million for violating the GDPR. So the GDPR really was a game changer when it came into force in 2018 because it superseded a law called the Data Protection Act of 1995, or Data Protection Directive, excuse me, and really tried to memorialize data protection principles that are catching up to the way that we do e-commerce now. And so a part of that, the Europeans have already taken data privacy very seriously. So they bolstered their laws with both these penalties, these fiscal penalties that organizations could face, but they also expanded and really clarified the extraterritorial application of the law. So to the extent that an organization is selling products or goods into European Union, they have online platforms that are monitoring the behavior of individuals in the European Union. They could be subject to the GDPR. And this is something that impacts a lot of my clients. And I think it's the thing that you and I talked about. It's so easy for organizations that are selling direct to consumer, that are using online platforms, particularly, for example, Shopify, make selling goods online very easy. They also make selling goods into Europe and into Canada and into Mexico very easy. It's almost like a click of a button, and then you have a distribution service that you can engage in, a marketing service that you can engage in, and it makes it very easy to start selling your products and services into the EU. And therefore, to the extent you're collecting end user data, whether it's business to business information or consumer information, you're going to be subject to the GDPR and the entire compliance regime that comes with it.
Yikes. So it pays to get ahead of this and have a plan and adhere to the laws. And if you don't know what the laws are, call someone like Steve and he can help you through it. But okay, so we're kind of talking a lot there about e-commerce platforms specifically. So through e-commerce platforms, it's easy for companies to sell their products outside the US and engage with some of these foreign audiences like you were talking about. So how do the U.S. laws specifically compare to that GDPR, those international laws that we were just saying? Because I know states like California have taken like a pretty aggressive stance, but there's other states that are like, what are privacy laws? So how do we think about some of that here in the States specifically?
Yeah, certainly. When talking about data protection laws, generally we think about privacy principles, if you will. And the principles are usually consistent regardless of the legal regime, regardless of whether in Europe or whether in the United States. For example, when talking about data privacy, the principles are based around transparency, accountability, security, data privacy rights. And what this means is that the laws that memorialize these principles memorialize them to a different extent, right? So the GDPR has essentially memorialized every single data privacy principle that you can think of. And we're starting to see that trend within the United States. So within the United States, the way that we're somewhat different is that we have the federal and state dichotomy in which the federal government has enacted certain privacy laws that are generally based on sectors or activities. So, for example, in healthcare, you have HIPAA, with the Secretary of HHS implemented very strict rules that healthcare organizations and healthcare plans have to comply with when protecting and collecting health information, right, on your patients, on your clinical trial subjects, things like that. Federal banking institutions, again, subject to very strict regulatory frameworks when it comes to collecting and retaining financial information. Education institutions and collecting student information, right? So you have the sector approach that the federal government has regulated. And then again, going back to activities, they also regulate marketing through email regulations, and telemarketing regulations would impact privacy rights around telemarketing and SMS marketing. At the state level, where we've really seen the trend in the last 5 years, or the last few years, going back to the California Consumer Privacy Act of 2018, was to start memorializing a lot of these data privacy principles more in the consumer context to reflect the GDPR. California is a little bit different because their privacy law also applies to HR data to some extent, job applicant data, almost to the same way that the GDPR is. And then this California law is going to change a little bit in 2023 to make it even more expansive. But then we have other states that we call the 3Cs and UV, right? California has their law, and you have Colorado and Connecticut who have a new data privacy law that will enter into force again in 2023. And Utah and Virginia also passed laws very recently that will enter into force in 2023. So those last 4 laws, the Connecticut, Colorado, Utah, Virginia, generally only apply in the traditional consumer context. And these laws are very similar to the GDPR in that organizations that collect consumer information have to provide notice to the consumers on how they're going to collect that data, right? And that's why we have so many privacy policies and cookie banners that are constantly popping up on websites, right? Those are notices that are meant to satisfy a legal requirement that has been imposed on these businesses. And the idea is choice, that if a consumer has the availability of information on how one business will collect and use their personal information, and they may not agree with that, then they can go to another organization. But the whole idea behind these privacy notices is we're giving consumers choices. These laws also require that consumers now have data privacy rights. If we're a resident of these states, we can request that businesses give us access to our own information, or we can demand that they don't sell our information, or they have to delete our information if it's in their custody and control, that they may have to amend it if our personal information changes, or we could dispute whether or not that information is accurate. So these laws, again, very similar to the way the GDPR has set up their data subject right process, these US state laws have now given rights to consumers that once the personal information goes to a business, that's not the end of it. These consumers now have rights to how the business can use, sell, process, dispose of their personal information. And then there's obviously a whole laundry list of other requirements that these states impose on organizations. But we're seeing a trend now because we don't have a federal law in the United States in the way that the GDPR kind of is that lowest common denominator in the EU. We're starting to see states really pass their own and debate their own data protection laws to apply particularly to consumers within their states.
Sure. So if we've got, California, Colorado, Connecticut, Utah, Virginia having their own little bucket of rules, but if you're selling on an e-commerce platform and you're selling all across the country, do you recommend then that clients take the approach of, making sure they're compliant with those states so that they know by definition they're compliant with everyone else? Like, how do you talk them through that?
Yeah, so some of these laws only apply to a certain subsector of businesses within those states, right? If they have $25 million in revenue, or if they collect $50,000 or 50,000 types of personal information on consumers, which is actually a pretty low bar when you think about how much internet traffic comes to your website, how many IP addresses you're picking up every single day. So again, we generally focus on those principles to the extent that you're going to comply with the law. If we provide you what those lowest common denominator principles are, right, transparency, accountability, security, data privacy rights, then you can applying those principles will make it easier to apply to all of these different data protection laws. The nuances really come within like timelines when you get to respond to data subject requests, when you get to do something called a data protection impact assessment. But to the extent you're actually complying with the principles and you're building out a privacy program, the nuances of the laws and the variations are pretty easy to account for when you're actually developing those policies.
Right. Well, that's good to know. I always think about privacy laws in a very interesting way, right? That we didn't really think about them that substantially until, a lot of times people were using our data, and that's why we have some of these laws, right? Like the old analogy, when you can boil the frog and the frog doesn't know it's being boiled. Like, we didn't know that our data was being used, but when you drop us in to the hot boiling water, the frog will jump out. We just didn't know that we were being boiled over time. So I think it's super interesting as we think about the schemas that are developing and how we think about this. Now, purely from a nerdy legal question, we're going to have all these different state rules and regulations, but this is really impacting international commerce. So do you feel that there's going to at some point in time be a federal rule, or do you think it's going to stay within the state's hands?
So we're pretty close to getting a federal rule now. I think the closest we've ever been in the history of the United States. We have a proposed American data privacy bill that's pending in the House right now. I'm not sure if it's actually going to pass, especially in the Senate, especially during an election year. But the unique part of this law is, again, it memorializes those data privacy principles that have already been enacted in Europe through the GDPR and the UK post-Brexit with your UK GDPR, as well in the States, particularly in Colorado, Connecticut, Utah, and Virginia. I think some of the issues we're going to see on whether or not this federal law actually gets enacted is going to be how it treats, whether it creates a private right of action, whether there's a cure period for organizations that do violate the law, that they do misuse personal information. Are they going to have an opportunity to cure those violations before a lawsuit can be filed? And then whether or not those federal laws are going to preempt state laws. And as you know, with California, their law is very comprehensive. It goes much further than we see in some of those other states in Connecticut and Utah and Virginia and Colorado. And so you have a delegation in California which may not want to vote for a federal law if it has a preemption clause in it, because
Sure.
and their constituents would then be, it wouldn't provide the same level of protections that they've already given their constituents. But again, if you don't have a federal preemption clause, then what's the point of having a federal law if we're going to have 50 state laws? But I think, if we keep the approach of going state by state, we've also seen this already in the data breach notification context. So every single state in the United States has enacted their own law that essentially says that if you've been subject to a ransomware attack or a data breach, you have to notify individuals that their personal information has been compromised. So we have 50 different laws in the books right now. But they're all similar because they all follow the same type of principles around providing notice. So I think if we continue to see this patchwork of implementation in the states, particularly in Colorado and Connecticut and Utah and Virginia, it's not, as long as those principles remain the same, compliance will be relatively streamlined. It's only when we have the outliers, like California, in which businesses are going to have to make significant differences to the compliance program. But again, we've done this in other contexts with data protection, so I think we can do it again. But if we could get a federal law that preempts state laws, I'm sure that would make it much
then
easier.
All of this, we're going to have to do it again. We'll just have version 2. All good, though. Okay, so moving forward then, can you describe then your experience in the M&A process and how you evaluate some of the data and cybersecurity risks that you might see? Because I think this is also what's important for startup clients or big corporations that are thinking about acquiring businesses. What are the things that you see that are real bugaboos in the process?
So obviously the first issue is whether an organization has been subject to a ransomware attack or a data breach within the last few years, few months, or going back a few years, because that's really indicative of the type of information security program that they have in place. And data breaches lead to significant litigation as well as potential regulatory enforcement. So usually we're focusing in on that issue right away. Along with that is what type of information security controls, cybersecurity controls that an organization has in place. Those technical, physical, administrative security controls. But more big picture, we're also looking at the culture that the organization has. Do they care about data privacy? Have they tried to make this a priority? Have they hired a chief privacy officer? Have they implemented any types of data protection policies within their organization? Are they providing their consumers or their end users with these type of privacy notices that are required by both federal and state laws? So it's difficult to assess. Every assessment we do clearly is going to be on a case by case basis on the organization, on their size, on their structure. But we come across way too many organizations that just haven't done anything. And so when we're asking our due diligence questions and they write not applicable to all their responses, it starts raising some red flags. And so we want to see at least some movement in terms of the data protection compliance, because we know as the purchasers, it'll be less work for us in trying to change the culture within the organization to align with the purchaser's kind of business model, which essentially, if you're going to be a purchaser, you're going to have a large compliance program in place anyway.
Yeah. Oh my. Okay. So yes. So this is, if it's not important to you at the onset, here's why it needs to be important to you on the back end, right? So it's an important thing that we need to be thinking about as our businesses grow or as we're thinking about acquiring businesses. So I guess last question, and we only have so much time here, but what does someone, an organization, need to do if they have been hacked or they've been subject to some sort of ransomware or something? I mean, what's the first phone call? Is it to you? Is it to authorities? What do they do? Walk them through at high level,
Yeah, so we usually recommend that you reach out to your attorney because they're going to lead the investigation under the attorney-client privilege, because you're thinking if you are subject to a ransomware attack that there could be litigation or regulatory enforcement actions. So you want to shield your investigation under the attorney-client privilege. So generally, you're going to reach out to your lawyer. Your lawyer is going to be in contact with your cyber insurance company because if you have cyber insurance, they're going to have a panel of either lawyers or IT consultants that you can use. You're generally going to bring in what's called a DFIR, a digital forensic information response organization, to run digital forensics within your IT environment. If you're subject to a ransomware, you're going to have a ransomware negotiator who's going to try to negotiate the prices of the ransom and make the payments through a cryptocurrency or some type of digital currency that they're using. So all of these kind of third-party service providers are usually pre-approved by a cyber insurance carrier. It's just making sure that they're properly aligned, that you're following the proper steps. And then usually on the back end is when you're doing your notification to your regulatory authorities, to your individuals who have been compromised. And again, you're going to follow those federal and state laws on the timing of making those notifications and the format and the content that needs to be in there.
And how quickly does someone need to react to getting those notices out? I mean, I'm assuming time is of the essence, but what does the timeline look like? If someone calls you at 11:30 at night and says, "Oh my gosh, we've been hacked," you're like, and then you tell them what to do.
Yeah, so some of the notices to regulatory authorities vary. I mean, the earliest ones are usually within 72 hours. You have to start providing notice to regulatory authorities. Some notices don't have to go to regulatory authorities until 30 or 60 days, or even under HIPAA context, it's 60 days after the end of the year if it's less than 500 people. So it's always going to vary. The information then has to go to the data subject, the individuals who are compromised. That's going to vary as well, but that's usually as soon as reasonably practicable, and that can be, the time frame can be within 72 hours, within 30 days. The idea is to provide notice to these individuals as quickly as possible, so they can take security measures to better protect themselves from identity theft, and things like that.
Wow. Okay. That was a lot. So that was hair blown back trying to drink all of that information in. So that would conclude our discussion for today. If you have other questions, please drop them into the chat and we will follow up with you after we wrap here and answer those questions to you separately. As a reminder, this webinar was recorded and will be available in our Thompson Hine library on YouTube, on our YouTube channel. So please remember to subscribe and hit that bell so you can get notifications when we put forth new great content like we just had here from Steve. So Biggest thank you of them all goes out to you, Steve. Thank you so much for sharing your wealth of knowledge on this topic. And please plug your book right now, too, because I would love for you to be able to share that if people want to dive in a little bit deeper.
Sure. So we published a data protection guidebook that contains a list of all the data breach notification laws within the United States, a lot of the information security laws, as well as some of the federal regulations, particularly the more recent guidance regarding ransomware payments and OFAC compliance, making sure you're not making payments to organizations on export control and sanctions lists. So the copy of the book is on our website. It's right there behind me, called the Data Protection Guidebook. You can order it on Amazon or just get in touch with us and we'll try to get you a complimentary copy.
Awesome. Maybe you'll even autograph it. We don't know. So again, thank you, Steve. This was wonderful. Super appreciate your sharing of your wealth of knowledge here today. I think this was a really awesome discussion.
Thanks so much for having me.
No problem. Thanks everyone for watching, and we'll see you next month.